Grayson. So I just wanted to pick up on one thing that Grayson had expressed, I think was conveyed. One of the things, keep in mind, one of the benefits of a Q-tip election is essentially you are electing to include those assets in the surviving person's estate, right? You are deferring the taxes on that and including in the surviving person's estate. So the government looks at that and says, well, if you're including it in the surviving person's estate, it too will have a second step up in basis for income tax purposes when the surviving person passes. So we talked about step up in basis. That's the step up that is to the fair market value when the person dies. So one of the planning things, one of the planning aspects that Mark had alluded to earlier was that we are looking at that now both when the first person passes and the second person passes. So for example, you might have a 50-50 split that Grayson was referring to, where everything was set up half to go to an irrevocable trust, half to go to the surviving person's side, and that's that 50-50 split. Well, what happens if your estate, at the time you created this, was a large, potentially taxable estate, but now, in the eyes of the exemptions, the threshold and the exemptions have grown, and so maybe that the taxable estate is not the size compared to the overall exemption. And you might be sitting there saying, well, great, I've got this 50-50 split there, and I have to do it. But I really don't need to do it, even for Washington state purposes, because my estate is not greater than one exemption. Right? Maybe the value of the estate is not greater than one exemption. Why should I have to do this? And what happens if I just split it 50-50? Well, now, if you have a 50-50 split, and if it qualifies, as Grayson was saying, for a Q-tip election, where all the income just goes to the surviving spouse by requirement, you can elect to include that first spouse's half in the surviving person's estate. Like you're bringing it all to the surviving person's estate, you're making that election, you're not going to have it excluded, and what's the benefit of that? It gets a second step up in basis for income tax purposes. So we really have two decisions now, potentially to think about when the first person passes: estate taxes and also income taxes.
What happens, let's say that much of the estate is in at-risk investments like stocks or mutual funds, and let's say the assets are at a peak at the time of this person's death, and then shortly after the market crashes and it's lost 50 or 60% of its value.
Yeah, so the question is, what happens if the market crashes, right? So herein is an issue with step up in basis. There is step up in basis, but there is also step down in basis. So if the security prices have gone down, it is the fair market value at the date of the person's passing. So you can have a step down in basis, unfortunately.
I mean, if the assets are still at risk, and then following the death,
They're lower.
They drop. Okay.
The new basis is not the acquisition price. The new basis is the fair market value at the date of the person's passing. So we think of that as beneficial.
That would be way up high.
Yeah, we think of it usually as beneficial when there's a market increase.
But the assets are down.
But conceivably there is a market decrease. And you can't have your cake and eat it too, right? In moments where there's a market decrease, your basis is not a basis step up. Your basis is going to be a basis step down, unfortunately. Right? So lower basis. That would be disadvantageous, yes. Usually we don't see that, but it can happen in certain recessionary periods. Yeah. All right, so we talked about choices. We talked about pros and cons of credit shelter trust allocation. We talked about certain types of funding, certain types of allocations and splits, and some of the pros and cons. I want to briefly talk about some of the administrative roles and some of the administrative issues that you need to think about when it comes to those credit shelter trusts. So as I see this, I think there's 4 things we want to briefly talk about. One, basically, is asset management. What type of assets are you managing, and are there ramifications for managing those assets that you've picked to put into the irrevocable trust, to put into that credit shelter trust? There are reporting requirements, or are there reporting requirements that you have as either as a surviving spouse or as the trustee to report to anybody while you are acting to manage this trust? What Grayson's mentioned net income, distributing net income. What is net income, right? I think we might have some basic ideas of what it is, but there's questions about what that is, and so we want to briefly talk about that. And then finally, when these trusts are created at the death of the first spouse, this irrevocable trust, because it's irrevocable, presumably has some reporting requirements insofar as tax returns are concerned. So we want to talk about income taxation, again, just briefly. And so these are 4 things I think we should be thinking about when it comes to administering any type of irrevocable credit shelter trust. So remember, the trustee, we've used this word, is a fiduciary. The trustee is a fiduciary. That simply means they are a steward over those assets. So as Grayson had said earlier, there's 2 beneficiaries in a credit shelter trust. The remainder beneficiary, the one who's going to receive it eventually, but then what's called the income beneficiary. So there's actually 2 people that are benefiting, the one now and the one later. And every trustee, the person who's managing that, under state law and under common law, has a fiduciary obligation to manage those assets, not only for the income beneficiary, but for the remainder beneficiary. So they really have some sort of split interest that they have to manage, both for themselves and for the remainder beneficiaries. So it's really important that when it comes to managing that, they follow what the trust says. So your trust, as you're looking at your trust, have to be really clear as to what rights you have as the trustee to manage those assets for the benefit of the income beneficiary and then eventually for the remainder beneficiary. So that's all and should be defined within the individual terms of the trust. So for example, as Grayson said earlier, if you have an individual trust that provides for HEMS or MESH, for health, education, maintenance, and support, those words have meanings, they have definitions. Maintenance, for example, has the common law, in other words, judge-made decision law that says that maintenance typically means maintaining your normal accustomed standard of care. So if you're used to, you're maintaining your lifestyle, then that's what maintenance means. Go beyond that, presumably, you might be going beyond what maintenance means. So it doesn't, again, the standard doesn't say whatever you darn well please to give to yourself. It says you must abide by for health, education, maintenance, and support. And because you are a fiduciary, you're managing those assets within that scope for yourself, keep in mind, you've got remainder beneficiaries. So there's a balance. There's challenges that are going on. In addition to that, there are issues as to the types of assets that you're managing. So for example, all assets may not be income producing assets. Maybe some are non-income producing assets. Maybe there's unproductive assets, but they're highly appreciated. Right? So as a fiduciary, okay, if you are managing that as the surviving spouse, as the trustee, or maybe you're not the trustee, maybe a child is the trustee, should you be holding on to that type of property, that unproductive property that is highly speculative? Or should you be holding on to a piece of raw land? Can you hold on to that property? And again, you probably should look back at what your trust document directs as far as whether or not unproductive property is reasonable to be held. Oftentimes, for example, when we're drafting documents like that, we'll direct within the document that if you are not the trustee, if you are not serving as the trustee, the surviving spouse can direct the trustee to convert unproductive property to income-producing property so they can produce income to draw the income off of for them as an individual beneficiary. Okay, so there's challenges with the types of assets that are presented. And again, one of these examples is what Grayson mentioned, a primary residence. So for example, if you have a primary residence, just from the standpoint of having that primary residence and having the challenges of two beneficiaries, both yourself and the remainder beneficiary, where would you want to put the primary residence? Would you want to put it on your side as the surviving person's side, where you have complete 100 unfettered discretion, or would you probably want to put it on the irrevocable trust side, the deceased spouse's side, where you have to look out for yourself and for the remainder beneficiaries, which makes more logical sense? Probably on your side, right? Because that's your house, it's your primary residence. So there you can look out for yourself in that case. So usually, we typically like to recommend, for example, on a primary residence, that the primary residence typically should be allocated to the surviving person's side. Okay, so, first idea, first concept is that there are fiduciary requirements that you have as a trustee or the trustee has to manage both for yourself as the income beneficiary and then for the remainder beneficiaries as well. Okay? Questions about that? Okay, second issue, reporting requirements. I get this question a lot. Do I have to report? Should I report? Do I have to report to anybody but myself? Jim, they are my assets. Why should I have to tell anybody about what's going on with these assets? And for a very brief period of time, a couple years ago, our state legislature enacted a new requirement for reporting purposes that essentially directed that those reporting requirements were mandated for every surviving spouse to go to every individual beneficiary. They had to produce annually a statement of income, a statement of expenses, assets and liabilities to the remaining beneficiaries. Now that has since changed. There are essentially three primary reporting requirements that I want you to remember. One, we have what we call a 60-day reporting requirement. And that 60-day reporting requirement basically says when this trust becomes irrevocable, the trustee, in general, must account to the beneficiary. So for example, if your daughter or your son was the trustee and they were managing for your benefit and there was an irrevocable trust, that son or daughter as the trustee must provide a statement to the beneficiary, to that individual beneficiary. And that reporting requirement is found on page 11 or slide 22. And those are the 4 items they must provide for. They must directly provide for the fact that there is a trust, the identity of who created this trust, the trustees' names, and then the right to request such information as would be reasonably necessary to inform them of their rights. So basically, here was the trustor, here's the trustee, there's a trust in existence, and you have the right to request that from me at any point in time. That's a reporting requirement. And it has to be done within 60 days following the vesting. That's a notification requirement. If you don't do that as the trustee, you've breached your obligation, your fiduciary requirement, and conceivably that's an offense that can be considered whether or not you're going to be removed as the trustee, that you breach your obligation.
Who does the removing?
Typically, that would be, if there was a removing, it would be done with inter-family members or beneficiaries. The beneficiaries have a right to that information, so they would have to file a claim. The question is, who does that removing, right, if there was ever going to be a removal of the trustee?
So if both parts, the husband and wife have passed and then it's going down to the trustees, at that point, same reporting requirements?
Same reporting requirements, exactly. So the question is, if, for example, when the surviving spouse dies, and there's a trustee at that point in time, and now you have a vesting of that to remainder beneficiaries, there is a reporting requirement by the trustee that they have to report to the remainder beneficiaries. And they have to duly notify them that there was a trust, that this is how it was created, and they have a right to request that information. The second reporting requirement is an annual reporting requirement. So the annual reporting requirement for credit shelter trusts are typically just general financial information. Essentially, you want to think of it as an informal accounting. I call it an informal accounting. So it's essentially showing what the beginning balance of the assets were, what the income was during the year, whether or not there was growth or loss, whether or not there were distributions, and then what the final ending balance of the account or assets are. That reporting requirement is typically made to what we call permissible distributees. So the permissible distributees, according to statute, are those people that are entitled potentially to any type of distribution. Okay, so where would that apply? Again, in the form of a credit shelter trust, that would apply if you were the beneficiary as the surviving spouse, and someone other than you was the trustee of that trust. So for example, a son or a daughter. That son or daughter has a requirement to provide you, no less frequently than annually, information pertaining to the management of that trust, including information on whether they're paying themselves any type of trustee fee for managing those assets for you. So that's the ANA reporting requirement. In addition, the third reporting requirement is what we call reasonable information. So reasonable information, a trustee has to keep what we call all qualified beneficiaries of a trust reasonably informed. Qualified beneficiaries of the trust are not only the beneficiaries who are the remainder beneficiaries, but those who would be the contingent remainder beneficiaries if that remainder beneficiary died. So where we see this sometimes in play is now if you have, for example, a blended family. So with a blended family, where you have a potential like a 50-50 split, like Grayson was talking about, where that happens, when the trustee, at that point in time, when the trustee comes into play to act for the benefit of the family when the first spouse dies, they have an information reporting requirement, a reasonable information requirement, that they have to notify beneficiaries if there's any beneficiary request for information. That request for information can come from whom? It can come from any qualified beneficiary. Who are the qualified beneficiaries? The children of the blended family or the grandchildren of the blended family, right? Contingent beneficiaries as well. So understand that right now, the reporting requirement essentially, if you are not a blended family, if you're not a blended family, the only person that really has the right to receive information are what are called the permissible distributees. Those people who are receiving income, which would be the spouse. So as a spouse, you're the only one that has the right to that information if you're in a non-blended family. But if you're in a blended family, if you have a blended family, then traditionally, blended families, the trustee does have to account to the remainder beneficiaries. And a general information report has to go to the remainder beneficiaries, arguably, in a blended family. That's sort of probably common sense, because in a blended family, with the blended family, you're trying to protect your rights in the blended family, but in the non-blended family, well, kids of the same marriage, the assets are probably going to go in any way to the kids in any event. Right? So the reporting requirements, there's a higher standard with a blended family. Okay? That's the second issue. Questions about that? Fiduciary obligations. All right. So Grayson alluded to net income. So what is net income? Well, net income can be all kinds of things. Trick question. Let's say, I'm going to go way out there. Let's say you have a retirement account that for some reason, we haven't even talked about this, but let's say you have retirement funds that they come into the trust, into the credit shelter trust, and it's taxable income. Is that net income to the trust? So when the trust says distribute out all the net income, is that net income? No, it's not net income. So net income typically is what we call, when we think of net income, it's defined by the statute, by the Revised Code of Washington, and it typically is income is thought of as proceeds from an asset. So it's typically a revenue stream. Net income is what we think of as, we call it fiduciary income. It's not necessarily taxable income. So what is always taxed is not necessarily thought of as income. So common income elements would be revenues from interest, from dividends, from rents, from royalties. That's sort of the common thought when it comes to what revenues are from net income. It's net income. So in addition to the gross proceeds, we also have disbursements out of that are disbursements that are expenses towards the cost of generating that income in the first place. So common distributions, that's defined here. You'll see that on slide 24, page 12, include items such as attorney fees, accounting fees, fiduciary fees, court costs, and other expenses. So those disbursements are commonly thought of as the expenses that help to facilitate the generating of that income, of that revenue, And that's what we define as net income. The proceeds plus net of the disbursements, and with that you have net income. And that net income is what gets carried out to the beneficiary or distributed out to the beneficiaries. As Grayson said, make sure that you want to understand whether or not your trust, your credit shelter trust, is a mandatory distribution provision that says all net income has to go out, or whether or not it says it's discretionary. Yes.
So an RMD would not be considered net income?
The question is, are RMDs, required minimum distributions, typically considered net income? And the answer is, at the state fiduciary level for Washington State, RMDs are not by default considered net income.
What about for QTIP purposes, distributing all income?
For QTIP purposes, when it says distribute all net income, typically it's the state standard. It's whatever is the net income.
Is the IRS going to say you meet the QTIP requirements if all you're getting from your retirement plan is an RMD?
No. Is the state going to say that you fulfill the requirements if you just are distributing the RMD? No. It's not just tied to the RMD. It's tied to what that account in the first place might have grown to. It's the revenue from that account in the first place. And so it's not tied to the distribution. It's tied to the growth from that account. Okay. Other questions? All right, so again, in most cases, net income, pretty basic concept again. If it's a rental property and it's producing rental revenues and it has rental expenses, it's pretty straightforward. But as I've mentioned, and as I've highlighted, net income is not always that easy. And so we do recommend to talk to your tax professional or your accountant to make sure that you're following the right understanding when it comes to your assets, whether or not you're interpreting net income correctly. All right, taxation of credit shelter trusts, the fourth element. So every credit shelter trust typically is an irrevocable trust, and because it's an irrevocable trust, it has a separate filing requirement. You should be thinking about whether or not, when you choose to create the irrevocable trust in the first place, you want to think about whether or not that's something that you want to enact for the purposes of handling the estate in the first place. In other words, if there's, for example, a disclaimer trust, you may choose to disclaim, you may choose not to disclaim. And one of the things you should be thinking about is, well, I have to be filing an income tax return every year going forward, and whether or not that's going to be something that is going to impact your decision on whether or not you're going to disclaim or not. There are fees related to the filing of individual estate and trust income tax returns. And you should be thinking about using a tax professional for that. So there's costs related to that. And that should impact your decision, or at least bear on your decision. So they have to file, traditionally trustees have to file a tax return annually, a Form 1041, and those are filed on a calendar year basis. So we pick a calendar year, January through December. Trusts can pay capital gains, or potentially they can pay income on the ordinary income as well. It all depends on what stays in the trust. So traditionally, as Grayson has mentioned, all the income within the trust typically is distributed out to a beneficiary. Those type of trusts at the taxation level are what we commonly refer to as simple trusts. It's just a tax terminology. Simple trusts are trusts that are required to distribute all the income. And so when you have a simple trust, what you're reporting to the IRS on this Form 1041 is you're reporting the taxable income that has come into the trust and the expenses that have paid out, and now you're reporting a net amount. That net amount is reported on the Form 1041, and you're also reporting to the IRS that that net income typically has gone out to the beneficiary because the trustee is directed to distribute out to the beneficiary. So the government looks at that and says, well, then who should bear the tax burden on that? So if the income is going out to the beneficiary, we can take on the tax return what is called an income distribution deduction. So the beneficiary themselves will end up effectively picking up the income tax on that, in the form of a K-1. So they'll receive a K-1 at the end of the year, showing the income that has come into them, and they'll pick that up on their tax return, as opposed to having it picked up on the trust return. Now, that's for state of Washington purposes, that's what happens for income purposes. But for capital gain purposes, capital gains are not income, says the state of Washington. And so when we talk about income being distributed, we're not talking about capital gains, we're talking about ordinary income. So, for example, buy Microsoft stock, sell Microsoft stock at a gain, that's the capital gain. That capital gain is what's not required to be distributed. That stays with principal, and it's kept within the trust. And so it is not carried out. So since the trust has that, the trust has to pay the taxes on that. Okay? So ordinary income typically is carried out to the beneficiaries. Capital gains typically are taxed at the trust level. Each individual trust, each individual simple trust, has an exemption of $300, and $100 is what's called a complex trust. A complex trust is simply one that is not required to distribute out the income annually. So for example, you want to think maybe of a complex trust as a trust that is a trust that's terminated, maybe in the final year of death of a spouse, when the trust is distributed to the beneficiaries. In that year, where there's no income distribution requirement to the surviving spouse, that's what we commonly refer to as a complex trust. That has a $100 exemption, unlike a simple trust.
So if you have a simple trust that has to distribute everything, how do you keep enough income to use the $300 exemption?
Yeah, good question. The question is, how do you keep enough income to distribute the $300 exemption? Come see me afterward and talk about tax plans, what that does. At your 1041 level, yeah, that can be tricky. So tax rates, just remember, one thing I want to point out here is that tax rates are steep with trusts. So I've given you the tax brackets essentially there. 0 to 2,000 in income is taxed at 10%. Roughly 26 to 9,300 is taxed at 24%. Essentially, it goes up all the way to 37%. Anything in excess of 12,750. Right? So tax rates are pretty steep, unlike for individuals. So your motivation as an individual trustee is never to keep income trapped within the trust, ideally, because ordinary income is taxed at ordinary tax rates if it's kept within the trust. Herein is why we oftentimes want to make those trusts require that income be distributed out, so that any income that is carried out is taxed at a lower level, that being the individual beneficiary's tax rate, which is probably going to be lower than the trust tax rate. Okay, so that's just something to think about. Try and move income out to the beneficiaries. Just a few other concepts I just want you to leave you with here. The last year, yes.
So one of the benefits right here of a complex trust is that you could retain up to $2,600 and when you pay 10% interest to essentially distribute all the rest.
You could, yeah. That is the question is there ways or planning that you should take into consideration when you have a complex trust? And the answer is yes, there is planning aspects to complex trust, exactly. So in the final year of a trust, there is a number of planning aspects to a trust that's terminated. When you have a credit shelter trusts are eventually distributed, and that's in the year of termination when the surviving spouse passes. And that involves some significant tax planning. One of those things that you want to keep in mind is there's what we call the 65-day rule. I just want to leave that with you. The 65-day rule essentially says if you distribute those assets, if you distribute the income out within 65 days of the end of the calendar year, then you get to have it as though that income was carried out in that calendar year. So you can pretend as though all the income was passed out to the beneficiaries and then pass it out to the beneficiaries at their tax rate. That's what we commonly refer to as the 65-day rule. Just a rule to keep in mind. For that reason, as I said, years of termination can be a bit tricky, and we really recommend you talk to your tax advisor or your attorney when you're dealing with managing a trust at the very end of the termination year. Yeah.
So are you saying basically by March 15th of the year following the death year, as long as you distribute, it's treated at the beneficiary's rate, tax
Now,
rate?
what I'm saying is that the question was, what are you saying, essentially, what does that date mean? And so what I'm saying is, if it's 65 days after year end, which would typically be March 5th, 65 days. So if it's by March 5th, then within that period of time, if the income is distributed by March 5th of the following year, then you can have that income be attributed to the previous year, and we can pretend that all the income was distributed to the beneficiary, and therefore it's carried out of the trust, not taxed at the trust level, and taxed to the beneficiaries.
Just the year of death?
No, in any administrative year. In any administrative year.
Oh,
All right, so the tax portion of this is highly complex, highly complicated, but I just want you to keep in mind that, again, there's a few planning aspects. One being capital gains. What are capital gains? What is ordinary income? And to try and remember, in general, it's usually advantageous to pass that income out to beneficiaries. And I have trust set up so that it requires that the income be distributed. Now, in any case, there's going to be exception to that. So you would always want to look at what your primary goal is, but just make sure that you're carrying out that plan with what the document is calling you to carry it out. So if the document says you are to distribute out the income, then you have to distribute out the income. All right, so those are four concepts of self-administering that I just wanted to leave you with today. Questions about any of those four planning aspects? Some fiduciaries, taxation, taxable income, anything else?
Yes, how would that work on a credit shelter trust if you have assets in the trust that you were selling, and then you were giving out, let's say $50,000 at a time or whatever to the beneficiaries, the children of that trust? Are they then taxed on that?
So the question was, in the year of termination, if a distribution is made to the remainder
Or
beneficiaries.
not even the year of determination, every year, because you have to, IRS, I understand, wants to make sure it's done within 3 years, but in this case, it wasn't able to be done within 3 years because it was real property and lots, difficult to sell, kind of a thing.
So if distributions are made in any year,
Yeah, the subsequent year after the first year.
then is income carried out or not to the beneficiary? And could there be tax in?
No, there's
tax
no income because it's just raw land.
Okay. So typically, if it's raw land that's being distributed out to the beneficiaries, that raw land is probably not going to be carrying out any side of type of income. That's principal. And so there's not going to be, typically in that case, there's not going to be any taxes attributable to the beneficiary.
So back to capital gains. In personal taxes, there's a threshold at which you exceed which taxable gains become taxed, and another one which become even taxed more. Are there thresholds or similar thresholds for trust?
Yeah, there are similar. So the question is, are there thresholds for trust versus individuals with capital gains? Yes. I think there are planning aspects or planning possibilities with regards to capital gains versus ordinary income. There's more, I believe, with ordinary income than there are with capital gains because the rates are greater. There's more disparity with ordinary income. Other questions? All right. Questions about anything that Mark, Grayson, or I have talked about today? Been a good audience. I appreciate all your questions.
Living trust, how is that different from the credit shelter trust? Or is it kind of flow over?
So the question is, living trusts, how are living trusts different than credit shelter trusts? So remember Mark said early on that community property agreements can happen and assets can go from one spot to the next in different shapes and different varieties and different forms. So the credit shelter trust can be created through a will or through a revocable trust, through a living trust. So you can have it in either one of those documents. So a credit shelter trust is one type of what we call testamentary trust. It happens, it's enacted at the death of a person. And that happens either in a will, or it can happen commonly in a revocable trust.
Call it a pour-over will then, if you have a...
Nope, no.
Is
It
that
happens in a
something-
traditional will, just a normal traditional will. And that will would be set up, for example, to say when a spouse passes, it goes to a surviving spouse. In the case of the disclaimer, it would say it goes to the surviving spouse unless the surviving spouse disclaims, and then it goes then to the trust if otherwise disclaimed. That same language can be in a revocable trust. It's going to be in one or the other. It's either going to be in a will or it's going to be in a revocable trust. So the revocable trust essentially takes the place of the will in that case.
We have a will set up along with our trust, living trust.
So if you have a will and a revocable trust, right, you will commonly have what's called a pour-over will that pours over the assets into the revocable trust. And within your revocable trust, if you have this type of plan where it's either a 50-50 or a disclaimer plan, you'll have that language within the individual revocable trust. So you should be looking in the revocable trust specifically for that language. Okay? Yes?
So Mark, in regards to asset protection of, in case you get into an accident,
Well-
you can get what we call a personal umbrella.
Right.
Right, that's one way to do it, right?
So the comment is whether or not your existence of a personal umbrella policy or a personal liability policy would have an impact on whether or not you choose to fund assets into a credit shelter trust or not. Would it? Yes, I think we would all agree that that would have some type of planning aspect and decision of whether or not you're going to create the individual irrevocable trust. Yes?
So on slide 6, where Mark talked about the exemption amounts, there's a column called gift tax, and Washington has a no. What does that mean?
So there is no gift tax for Washington state tax purposes. There's only a gift tax for federal purposes. Right? That is not necessarily very easily understood, but Washington state does not have a gift tax. Washington state has an estate tax, but they have no gift tax. So there is planning considerations and planning opportunities for people that have estates greater than the Washington threshold, but don't have assets as much as the federal threshold. And there's gifting opportunities for those people. So if you are somewhere in between that level, you might think, well, can I gift? And the answer is yes, you can gift. Because if you gifted, while there's potential income tax consideration to think about for gifting, if you gifted, you're never going to get to the point where you're going to gift to the point where you're going to be faced with a federal gift tax. Because currently under state law, there is no federal gift tax.
You can file a tax form 706.
You can file a Form 709 gift
Seven-
return. Yeah, if the gifts are more than $15,000 per person per year. All right, so one of the things that we provide in all of our seminars is a feedback form. We would really appreciate it if you would fill out that feedback form and let us know about the information that you received today. And please do tell us if there's other areas, other topics of interest that you'd like to hear about. We, whether that's Ryan or myself or Mark or Grayson or any of our colleagues, we take your feedback and your comments very seriously. And so we want to hear if there's other information that you would like to have us present. So if you could take a few minutes to complete those, we would appreciate it. And you can leave those with Tammy when you leave today.
We don't have any children, and we do have nieces and nephews, but they're all busy raising children. I don't have a feeling they had any idea what they were coming up against. They would just simply say, no, I'm not interested. So my question is, are there people that do this professionally? That you can show your trust and talk to them about it?
So the question is, are there people that do the trustee work professionally?
Yes.
Yes, that's something that we talk about in one of our seminars. Is who's the best choice to serve as a trustee? As you can see in some of the things we've talked about, there's some easy concepts, but there's some very difficult concepts to follow too. And all that said, that the trustee really needs to have professional guidance in distributing assets and their responsibility as fiduciary. And it's up to you to pick the appropriate person to choose who's going to be the trustee. And there are professionals that can serve in that capacity, from accountants, CPAs, attorneys. There's professional trust companies that do that. So if you don't want necessarily an individual to serve in that capacity, that is an alternative for you. That's something that you'd want to have a conversation with your family, but also with the professional too, to give you some advice as to who would be appropriate in your circumstance.
I think we didn't realize how complicated this might be.
Yeah, it can, there are things that can be complicated, right? All right, thank you all for your attendance. We appreciate it coming out. As Mark said, on the